All right, so it's Jodio, and I'm here with my really good friend John, who is a patent attorney.
That's right.
As long as I've known you, all you have done has been patent work. It's been amazing just to
Yeah, it's been like almost 30 years,
30
which
years.
amazes
Wow,
me.
that is so awesome. So you do patent work for technology companies. I think New Relic is a customer, for example.
Yeah, I do the full range. So I do high-tech startups all the time. That's very common. But then I also have some regular corporate clients,
Hmm.
which I've had for many years, and they're very helpful for paying the bills, and it kind of finances my work with some of the startups. So
It's very startup friendly of you.
yeah,
Awesome. Well, I think so. In the founder culture community, there are a number of earlier stage founders through scaling founders. So maybe we can just talk about a little bit about the startup arc of growth and when it's smart to do certain things from an intellectual property or trademarking or copywriting
right.
perspective. And so I guess I would start by just maybe some really basic definitions, because I think a lot of startup founders don't really even understand the differences between the different types of work that they could engage you to do. So, what is patentable in the software world? How should a startup founder be thinking about patent, and how does that compare to other types of work like trademarking, etc.?
Yeah, well, actually, we should talk about three things. One is copyrights, which is what's going to protect your software. Patents, to a lesser extent, will protect your software. Copyright is the main form of protection. Trademarks for your business name or any product names, and then patent, to the extent we can get it, is really great protection in terms of keeping your competitors out of your field and
Mhm.
protecting your business. So,
And so if I write code and I have a code base, I can copyright that code base or
right,
that
and
code, or how
so
does that work?
the copyright laws are very positive and helpful towards startups and individuals. The copyright laws don't require much in terms of what you have to do in order to get the copyright protection. And mainly, it's just correctly marking your software or your business materials with the correct markings.
Mhm.
And then once you've done that, the law automatically steps in and gives you a great deal of protection. So, to the extent we're talking about copyright and protecting your code and also your business materials, you really just need to consult with an IP attorney and ask them, what do I need to do in order to ensure that this protection applies to me? It's very simple, but you have to do it right. That's all.
Okay, so this is actually even like doubly important, because if I'm an earlier stage founder and I'm thinking, oh my God, I don't want to spend $50,000 to secure
Right.
some patent protection. There's actually things that I can be doing if I just know to do them
Right.
earlier in the startup journey. So that's very
Yeah.
important information.
I mean, and yeah, it's like a half-hour consult with a guy like me gets you a lot of knowledge that you can then use to make sure you protect yourself. One is the copyright. On the trademark side, if you have a business name or if you're using product names in your literature or online, it's really helpful to simply mark it with the TM symbol, and then you put the world on notice that you consider that your intellectual property, your trade name, and anybody that comes in and tries to use it, you can say, well, no, I put you on notice. There's the TM symbol. That's my mark. So,
I think one thing I hadn't realized before was I thought that that TM symbol had meant, I need to go out and get some sort of a registration from the government to use that TM symbol. But what I understand to be true now is the TM symbol, I can just start using it if I think it's trademarkable. And then when it's actually registered, it turns into that R with a circle. Is that,
correct. Yeah.
yeah, yeah. So that's an important distinction too. Just start throwing the
Yeah.
TM symbol around.
And this is actually another important thing to realize about trademark law, which is that you don't have to do much in order to get a lot of protection. Your trademark rights don't really arise through registration with the government, which is the case for a patent. But in the trademark world, your rights arise just from use of the mark. If you go out and use the mark in public, you're putting it on your website, you're talking to people with your mark, that's where your rights come from in the first place. And you don't even have to register your mark in order to get a lot of protection in court. It's helpful if you do. And it's also helpful to the extent that if you register it, you then are in this database that everybody looks at.
Mhm.
So I would say two things for startups on trademarks. One, before you adopt a name and invest much money and time into it, please check it first. Have a reputable IP attorney go do a search and make sure that nobody else is using a similar mark for similar services. If not, fine, you're clear to proceed. You don't have to go through the registration process. Just go out and start using the mark, because that's where all of your rights are going to arise from. And then, to the extent your business is working and it feels like you're getting some traction, then you should come and talk, and we'll get it registered for you. But you got to check first before you adopt it. I've seen this over and over again. The other thing I would say about this is many people at the initial stage tend to adopt marks or trade names which are descriptive of their products. That's very difficult to obtain meaningful protection for a descriptive mark. And so I'm always pushing my clients to select fanciful words that don't necessarily have any meaning in your trade or industry. Something that is not descriptive is very helpful down the road. So, there are a million examples out there, like Apple for computers. Apple has nothing to do with a computer, but it was a fanciful name, and it now has great protection.
So, what if there is a name that is already registered, but it is in a different field? So maybe it's a clothing line or something that has nothing to do with technology.
That's a very good point. The only thing that should block you from adopting a name is somebody using a similar name or the same one in a very similar field. And to the extent the fields are very different, it's very common for exactly the same trademark to coexist happily without interfering with one another.
Okay, so that is trademarking, another simple thing.
Yep.
Copywriting, a simple thing. When should a founder do these things? Is it when they first raise their first round of seed financing, or when they're getting a little bit of traction and it's something that's worth protecting, or how should they think about timing?
Right. Timing for copyright, please go talk to somebody and figure out the marketing requirements and do that from day one, before you even seek funding. And sort of a similar answer for the trademark side, you want to make sure any names that you're adopting are going to be clear and you're not going to run into trouble down the line. So that's something you should do as early as possible. And the trademark search to ensure that you're not going to trample on somebody else's rights is actually fairly inexpensive. You can get it done for, maybe less than $1,000 per name. So it's this is one of these situations where a small amount of money now saves you a lot of trouble and money later. So.
And the search that's being done is in the USPTO database. I guess
partly, yeah. They definitely need to. That's the first place you check, because if it's a registered mark, then you definitely don't want to adopt it. But we also check those marks through just regular usage. It's common for people to adopt and use a trademark that they never register with the trademark office. So that's only the first step. We also look for all other uses of a similar mark.
I see. Okay. All right. So let's imagine that I am a very buttoned up startup founder, which startup founders typically are not very buttoned up. So this is helpful. And I've done these things. As the startup is maturing and growing, let's say that I am, maybe I've raised a Series A. Series A used to mean I've raised, something like $10 million. Now it's maybe I've raised 20 or more.
Yeah, that's true.
So I've got a good amount. I've got seven or eight figures worth of cash in the bank. What should I be thinking about now?
Okay, so at this point, it's time to start talking patent, and that means trying to create some intellectual property that is going to keep other people out of your business space. And there's kind of two ways to go at this at an early stage. If you think you have a killer idea, then it's time to talk about doing a full-blown patent application. And they're costly. You're probably going to spend a minimum of $10,000 or more to get a patent application filed with the patent office. And then there are more costs as you go through and try to get that patent application turned into an issued patent. But if you are at an initial stage and you're trying out ideas, there's a much less expensive way to go at this. You can file what's called a provisional patent application, which is really just a simple description of your idea. We often file the provisional application with the marketing materials or the materials you've already prepared to show to investors. The filing fee is only like $150. It's cheap. So for less than $1,000, you file a provisional patent application. You've gotten a filing date that's established with the patent office. And if you, over the ensuing year, find that this is an idea that has some real value and it's going to go somewhere, then at the 1 year mark, we turn the provisional into a regular full-blown patent application and we seek real patent protection for it. So the provisional patent application is a great way to go at an early stage when you don't have a lot of money to spend, and also when you're not even sure if the idea you're pursuing is going to take off.
So uh, a smart way to do this then would be to pursue a number of provisionals at $1,000 each, or
Right.
do you try to scope the provisional to be as broad as possible, or is it better to do a number of targeted provisionals?
Well, typically, we're just going to file everything we know about your idea, and it's held in confidence by the patent office. So, unless you actually turn it into a regular patent application, nobody's ever going to see these materials. So, we just give it a, we throw
Just
in
throw
everything we
everything at
can.
it,
Yeah,
yeah,
throw everything we can in.
as broad as possible,
Yep,
effectively. And
exactly.
then we have a year to decide. So we've spent $1,000, per provisional. We have a year to decide. Okay, this has enough legs that we want to pursue an
Right,
actual.
right.
And then if we do want to pursue something like an actual patent, you said that the cost would be $10,000 starting or more, and I
Yeah.
assume that is based on how much you have to justify the different claims, is what I'm guessing. But I'd
It's
love to understand a little bit about like the range of cost for a patent and when it's
sure.
incurred. Is because it's not all incurred at once,
No, it's
right?
not.
Yeah,
Well, the thousand, the 10,000 is incurred at once.
for the big meaty full patent
The
application.
application,
Yeah.
yeah, and you're paying for me or somebody like me to go in and do a really good description of what you've created, and then also think hard about how to try to claim that in words, which is often quite difficult in a software-related
Hmm.
invention. And so let's just talk briefly. A lot of high-tech startup inventions are software-related these days, and that's one of the things I've focused on for the last 15 or 20 years. It's if you engage a guy like me, he's going to be able to tell you up front whether or not you have a reasonable chance of getting a patent on a software related invention. It can be quite difficult. Then software related inventions are not looked upon with favor, generally speaking, by the US Patent Office, and indeed, many foreign patent offices won't even entertain them.
Hmm.
So you need to get a fair, good read on whether or not you're likely to be successful before you start spending this kind of big money on a patent application. But you just need to be aware that there are some software related ideas that are going to be fine and they'll go through and you'll get some protection, and others where it's almost hopeless and not worth spending the money.
So you would basically provide a kind of like probability assessment
Right.
of
And of
whether.
course, none of us are 100% accurate
Right,
on this,
right.
but after a bunch of years doing it, we can give you a pretty good idea.
And what exactly is patentable? So and does it matter if I've already been using it out in the world
This
or
is a very
not?
good point to hit. Yeah. Um, it, it the subject matter is so broad ranging that it's impossible for me to give you an idea of like, well, here's what's patentable.
Mhm.
You should just consult with a guy like me and figure out if what you have is patentable. And everything is down to the details, so it's impossible to do this ahead of time.
Mhm.
But this there is a time bar, and that's worth talking about. If you have been actively publicly using your invention for more than a year, then you probably cannot get a patent on it. You need to have filed within 1 year of that first actual use and disclosure to the public.
Mhm.
There are exceptions for this if you are doing some testing and you're doing some real world testing on your ideas. There's sort of an exception, but it's narrowly drawn. So you should in your head be thinking, if I have begun to commercially use one of my ideas, I've just started a 1 year clock
Mhm.
ticking to get something filed.
So effectively, maybe the way to think about it as a founder is I've got 2 years. I start to use it. I'm testing it.
Yep.
I'm like, oh, okay, this is worth spending $1,000 on.
Right.
File the provisional. Effectively, get a place in line with the USPTO.
Yep.
Have another year to file for the full patent.
Right.
So a 2 year window. That's a really really helpful way to think about it. And then, how do you see companies using patents most often? Is it in a defensive posture, offensive posture? Just what's the value of getting a patent?
Well, I think probably relevant to this conversation is if you have a startup business, um, the patents are a way to keep other people out of your business space, and that's very attractive to people that are investing in your company. So having decent patent applications on file, and God bless you if you can get them quickly, actual patents, this is very helpful in terms of getting your company funded and showing that you have a viable business. Longer term, I find that most software related clients are using their patents more defensively than offensively. And by this, I mean, if you are suddenly getting attacked from somebody else in your business space with their patents, you can turn around and say, well, I have 5 patents that you're infringing, and then you have a basis for quickly settling without anybody spending a lot of money.
So it's leverage.
It's leverage, and it's very important these days. And just to give you one quick example, the telephone company Vonage, when they were in their early days, they did not pursue patent protection, and they were immediately sued by MCI and Verizon. And I think Verizon got 150 million out of them, and MCI took another 80 million out of them, and it crippled them in their early days. They just took away all their cash. At that point, they turned to a very robust patent protection program, and in the ensuing 5 years, got like 100 patents issued, and everybody stopped attacking them. They quit. They just quit it and left them alone. So.
Did you have anything to do with those patents that were issued?
As a matter of fact, I did, and now we have the very nice patent portfolio for Vonage. So, yes.
So, okay, that's good to understand. I think as a startup founder who's extremely time poor, the number one thing that I would be thinking about is like, oh man, I've got engineering teams, I got product teams. They're so busy building. It's a real big distraction for them to actually take the time to write this stuff down. So how do you typically work with these technology companies like a New Relic to work efficiently? Because it's almost like the time is the asset that is so much more scarce than money. Like a company's got tens or hundreds of $1 millions of funding, just no time.
Yep. Well, yeah. The process of extracting ideas out of your business and getting them down onto paper for me to use is not efficiently done by the people at the company. I do that, they don't. So the way this typically works is we will schedule maybe a quarterly meeting with your engineering and development team. And I'd come in and ask, okay, well, what are you guys working on these days? And we have this nice discussion, and they identify anything new that's come up. And then I evaluate it at that point and determine whether it's worth pursuing in a patent. And there may be many reasons not to pursue even a very good idea. But if we identify one or two that are worth pursuing, then I usually simply take that conversation that we just had back to my office as a recording and draft a patent application from that, and then present it to the people who are considered inventors. So there's no time spent other than maybe a 1-hour meeting with me in order to do that technology transfer of the ideas. So this is the most efficient way we've found to do it.
Okay, so I am basically giving up my team for an hour a quarter for effectively a brainstorming session.
Right.
In that brainstorming session, a few ideas are identified. You go into some detail. I assume you probably get a lot of materials from the team. So.
No, I almost never get anything.
Oh, wow. So it's all done?
We just talk.
That's amazing. Wow. Okay, so you are basically translating the engineering or product speak into patent speak. You're basically a very complex translation machine. Yeah. Got it. Okay.
And then I give them a patent application, and by and large, the inventors go, "Oh my God, I'm so brilliant! Look at
this." Your job is to make other people look amazing.
Right.
Yeah, that's great. And I think one thing to mention here is the value of lifting the people up on your team and giving them an opportunity to become inventors. I think that's also just worth calling out, because it is, I think, for somebody's career, it's a very special moment to even just go through this process, but then be listed as an inventor.
It's true, and inevitably, the people that are listed as inventors on the patents at issue, I mean, that goes right on their resume, and they say, "I'm an inventor on the following patents," and that's, that holds weight. It really does.
Yeah. I mean, we are a society that is built on invention. You've got your American flag back there,
Yep.
And I don't know. I think it just goes with startups so beautifully to honor the people. It's not just us as CEOs or executives, but it's the people in the company that are creating the engine that is driving the innovation, and to be able to honor them with a patent, it's a super special thing. And by the way, if you do get patents for your companies, highly recommend getting one of those beautiful plaques and sending it to them with a note, because that is just like having them put it on their wall is just like the proudest moment for them. So
and there they are, their name right on the front of the patent.
They're so genius. Okay, so what else should startup founders know about your world that we didn't cover? Any other, especially mistakes that you see people make often that are kind of hard to recover from?
The mistakes I see most often are trying to engage a lawyer like me to pursue ideas that aren't going to help the company in the long run. And so this is a difficult thing. When I step into a company for the first time, I consider that I'm beginning a long-term relationship and that I'll be with the company for as long as the company exists. And so I make it a point to spend a lot of my time not billing the client, but just spending time getting to know their business and figuring out what's important to them and where they're going with it. And if you do that up front and then check in regularly so that you know where the company's headed, it makes it much easier to advise them about whether to pursue a certain idea with a patent, or whether to just let one go, or whether to hide one from the rest of the world because you don't want to see the idea at all. So that's important. If you get a good patent attorney, he'll do what I do, which is spend the time to get to know you and not charge you for it, which I hate seeing that. So that's one. The other thing I typically do for most of my startup clients is I tell them, as we do those quarterly meetings and try to figure out what to pursue, all that's also free to you. I'm not going to start charging you until we've identified an idea to pursue, and I actually start to write a patent application on that idea. So be wary of patent attorneys that come in and tell you there's a consultation fee, or you're going to have to pay for all their time to drive over to your office and then spend time with you talking, and then for them to drive back. These are not the guys you want on your side. You want somebody that's going to be with you for the long run and is going to get to know you and care about you.
That's great advice. Very, very much in line with the ethos of founder culture as well. So
yep.
I appreciate you. Cool. All right. Well, if you want to talk to John, we'll see if we can convince this guy to join the community as a subject matter expert, and then you can have a conversation with him about the timing, because many of you are probably thinking right now, oh man, I should have already started this process.
Never too late.
Never too late. Okay. All right. Thanks for all the expertise. Appreciate it, man.
Happy to be here.